Hello everyone, I am Shilpi Gupta and in this video I am going to discuss about the general defenses of tort. So what is general defenses? Whenever the defendant has done any act violating the right of the plaintiff has a right to file a suit against him and get the remedy if he successfully proves the essentials of tort. However, there are certain circumstances under which the defendant may avoid liability by taking the plea of defenses. These circumstances are a list of general defenses. This list is given here. I will discuss in this video the 10 points of justification, that is voluntary non-fit injuria, act of God, inevitable accident, private defense, acts of necessity, mistake, statutory authority, judicial acts, parental and quasiparental authority, acts causing slight harm. The first defense is voluntary non-fit injuria. It is said that every man is best judge of his own interest, and if he gives his consent to any act and after that he suffer any injury, then he cannot complain anyone and he cannot make anyone liable for that. So in this defense, the defendant will have to prove that the consent which was given by the plaintiff was free and voluntarily given. In Hall versus Brooklyn Auto Racing Club, the plaintiff was a spectator in the defendant's race club. During the race, suddenly two cars collided and one of the car was thrown on spectator, because of which the plaintiff got injured. In this case, it was held that the defendant not liable because he impliedly gave the consent to suffer the damage which was incidental to such sport. Act of God or vis major. Act of God means any act which a man cannot avoid even by taking reasonable care, and if any accidents happens due to such natural forces, then the defendant can take a valid defense. These acts are earthquake, storm, flood, etc. In the case of Nichols versus Marshland, an artificial lake was created on plaintiff lands due to storage of rainwater coming from a natural stream. Once there was a heavy rain, because of which the embankments of the lake burst out and water overflow, which damaged the plaintiff lands. The defendant here was held not liable as the accident was due to extraordinary heavy rain and was not the fault of the defendant. Inevitable accident. If an unexpected injury which could not be avoided by reasonable care also on the part of the defendant happens to the plaintiff, the defense can be taken by the defendant of inevitable accident. In the case of Stanley versus Powell, the plaintiff and the defendants were members of shooting party. The defendant fired at a bird, but unfortunately the shot from the gun hit an oak tree and rebounded upon the plaintiff. The plaintiff got injury. So this particular incident was an inevitable accident and the defendant was held not liable although the plaintiff has suffered injury. Next point is private defense. So every person has a right to protect his person or property, and for that purpose he can use necessary force. Thus, if a person uses any necessary force which is required to protect his person or property from any harm which he thinks it could be, then it is justified on his part and he can show that he has caused that injury to other because of protecting himself. In the case of Bird versus Holbrook, this private defense was explained. In this case, the defendant had put a spring guns in his garden, but he has not fixed any public notice about that. and as such one of the trespasser entered into the garden and was seriously injured due to that. In this case, it was held that the plaintiff was entitled to recover damages because the force which was used by the defendant was excessive and he has not placed any public notice regarding that spring guns. As such, he can recover damages from the defendant. Act of necessity is based upon the maxim salus populi lex, which means welfare of the people is the supreme law. As such, if a person causes any damage in order to prevent a greater evil, then that action will not be liable. For example, if a person throw water on a house in fire or put it down in order to stop the further spread of fire, that act is definitely done in necessity and the defendant will not be held liable. Next justification is mistake. Mistake, whether of fact or of law, is generally no difference to an action of tort. For example, if a person enters into a land of another, he cannot escape his liability and he will definitely be a trespasser. Similarly, if a person injures the reputation and says that it was under a mistake, then also he will be liable. However, there are certain torts where malice is required, such as tort of malicious prosecution. And if in this type of tort the defendant proves that he has done the act honestly and mistakenly by a belief that he was doing what was correct, then he can be escaped from the liability and he can get a valid defense. Statutory authority. If the damage is caused to a person by an act under any authority of the legislature, he cannot bring an action against the authority, and in such cases, if law permits for any compensation, then only he can claim such compensation, otherwise not. This can be explained by a case of Vaughan versus Steff Railway and Company. In this case, the respondent railway company had been authorized to run the railway. One day, sparks from the engine set fire to the appellant's woods, which was on the adjoining land, and thus great damage was caused to the appellant. It was held that since the respondent had taken proper care in running the trains, they were not liable. Next is Judicial Acts and Quasi-Judicial Acts. The judicial officers are exempted from any liability for any work done by them in the discharge of their judicial duties, even if they have done by malice or not done honestly. This exemption is given to them so that they can discharge their functions independently and without any fear and favor. Next is parental and quasi-parental authority. So, parents and guardians had an authority to chastise their children. If their children does any wrong, they have a right to detain them and show them the correct path. A father can stop his son from doing anything which is wrong and to show him the correct path. Similarly, the teacher has also the right. However, the ward or the student cannot bring any action against the teacher or the father because they are doing it under the parental and quasi-parental authority. Last one is acts causing slight harm. There are some types of mistakes, some types of harm which are very small, trifles. That means they are so small that for those type of wrong, generally no one complains. For example, dashing a person while walking on public road or falling of dust or water caused by fast running of a car. In such type of incidences, no people will go and file a case against the defendant if he has done any such type of dashing or pelting of water, because if the court will entertain all this slight harm, then there will be lots and lots of pending cases. As such, these types of injuries are considered to be trifles and the defendant can get a benefit of these type of actions if brought against him. So with this I have already covered the entire topic of justification of tort. I hope this video will be helpful for you. Thank you.